Okay, so welcome to this podcast entitled Caveats and Priority Notices. I'm becoming better at estimating how long my podcasts go for, so I suggest this one goes for 20 minutes, or just under. Here we're going to be talking about caveats and priority notices under the Torrens system, the Land Title Act Torrens system of registration that we have in Queensland, what these documents are, and how they can be used, what they look like, and a couple of basic examples so you can get your head around this area as well. So recall that the operative section of this principle of indefeasibility and the Land Title Act, the whole Torrens system is built around this concept of indefeasibility. So a registered proprietor of an interest in a lot under section 184(1) holds that interest free from all other interests except for registered interests, right? So that doesn't necessarily just mean the owner of the lot. It can also, that is the person who owns the fee simple, it can include also a person who is a tenant under a lease, if they've registered their lease, and a bank or some form of a lender who's the beneficiary of a mortgage over the lot, and therefore can put a charge on the land and register their interest in that land. So it depends how you read that section. Talking about the registered proprietor of an interest in a lot, you could be talking about the bank. In other words, the bank with a registered mortgage holds their registered mortgage subject to all other registered interests but free from unregistered interests, for example, unregistered mortgages, and the same with a lease. If there are two leases out there and one of them registers it, the other one doesn't, then the one who is registered on the title is likely to get priority over the other one. Let's talk quickly about caveats. So caveats, obviously comes from that Latin word meaning beware or stop. You've heard of caveat emptor, buyer beware. So talking about a similar type of concept, right? So it's really a provision that notifies everybody under the Land Title Act system that there is some interest that needs to be determined. For example, a dispute that needs to be determined prior to anything else happening, prior to any other dealing happening with that lot. So they're set out in the Land Title Act, and you can look at sections 121 through to 131. It talks about what is a caveat, essentially, how to lodge one, how one might be withdrawn, essentially how a caveat can lapse, and also talks about the function of the caveat, the effect of lodging a caveat under section 124 there. And I'll go into it in future slides so you understand a bit better what I'm talking about. So here's an example of a caveat. So remember the real property, the Land Title Act system is about registration. So it's about registering your interest in land. So let's just say that we had an interest. In this case, we have somebody who owns the fee simple, and they might own lot 16, right? On this example on the right-hand side, lot 16 on registered plan 32361. Now, you can see the next item there says interest being claimed, right, and state in fee simple as purchaser. So this person, the caveator, being John Thomas Clare in this case, is lodging a caveat to try and protect their interest, which is not yet on the register. So they're saying that they've got an interest in fee simple as a purchaser, and that there's been a contract that they've signed. And I refer you back to that video that I made about the process of signing a contract for the sale of land and when it actually settles, so you get a better understanding of that process. Right? So obviously there's been some contract which has been signed here, but the caveator, that is John Clare, has not yet become the registered owner of the fee simple. Hence why they're lodging this caveat. To try and freeze the register would be the effect of a caveat, to try and stop anything else happening with that particular lot until this person's interest, John Clare, has been decided by a court. So what happens is they lodge this caveat, which is a document, right? And if it's accepted by the registry, it will essentially freeze the register so that no other dealings can happen until this claim, you can see there item force is the grounds of the claim, until this dispute between John, who's claiming an interest as the fee simple, and who's the other person, also called John, who probably currently owns the fee simple, until that dispute is remedied, usually by court action. So you can see here section 124 of the Land Title Act talks about the effect of lodging a caveat. A caveat prevents registration of an instrument, that is any other instrument, affecting the lot from the date and time endorsed by the register. So in other words, it freezes the register. So I'll put down there for a picture of Mr. Freeze, if you've never seen that movie before. That's Arnold Schwarzenegger playing Mr. Freeze in Batman and Robin, one of the several editions that there now are. And so you can think of it as a game of musical chairs. So you've seen the picture I put on the left-hand side. You've got this register where things can be dealt with over the register. People can register their interests in lots. But this lodging a caveat and claiming some interest, usually some dispute, right, will have the effect of freezing the register so that this dispute can be worked out, and it essentially tries to protect the interest of the person who's called the caveator. Right, section 1264 of the Land Title Act says if they don't want their caveat to elapse, they must start a court proceeding. And it's got two sections there. If notice is served, then it's going to be 14 days. And if notice is not served, then it's got to be within 3 months. And if the caveator, in other words, if they don't start their action within a certain period of time, whether it's 2 weeks or 3 months, depending on whether they serve notice, then the caveat essentially lapses, falls off the register, and then other dealings can be dealt with on that register. So here's a practical example, which is a very basic one. You might recall reading this case of Brescovar and Wall, and we'll talk about this case probably several times throughout the semester. Here we had the Brescovars who owned land in Brisbane. They wished to borrow against it. So what they did was they executed a blank transfer document. Naughty, naughty, very silly. Shouldn't have done that, but they gave it to this guy called Petrie. Why did they do that? Well, you know, in those days, some people did this type of practice as security for the loan. So Petrie would have given them some money, and they said, here's a blank transfer document such that if we default, you can insert your name in it, you know, then you can have access to the property. Of course, these days that's very silly. We would just have a mortgage system, right? And also in this case, Petrie was fraud, right? So Petrie, what he does is instead of waiting until they default on the loan, he just inserts the name of his grandson, Wall, who's also implicit in the fraud, into the document. So then what happens is you have Wall, who's the grandson, try and sell the property to this other company called Albin. Albin doesn't know about the fraud, right? So they're a bona fide purchaser for value without notice. So what would happen, let's just assume that last dot point hasn't happened yet, what would happen if Albin, the contract between Wall and Albin settles? Albin essentially becomes the registered owner of the fee simple, right? Albin didn't know anything about the fraud. Their interest is going to be indefeasible. We'll talk about exceptions to that rule, but that's the general premise of immediate indefeasibility. Under section 184, subsection 1, they only have to take their interest subject to other registered interests. So what do the Brescovars do? Well, prior to settlement, they run off and they lodge a caveat, right? So this is a perfect example of where something has happened off the register, right? And or something has happened that they're saying there's going to be something bad happen, i.e. for us, the Brescovars. We need to quickly put a stop to anybody dealing with the register so as to protect our interests. So they lodged a document called a caveat, and they would write in the interest being claimed, look, we claim the fee simple interest in this lot by virtue of the fact that we've been defrauded by Petrie, and please freeze the register and don't do anything about this. Don't let the contract settle in favour of Albin until such time as we can sort out this fraud. Because once it actually changes hands to Albin, the Brescovars have no recourse. So in this case, we end up having what's called a priority dispute, because we have the Brescovars who are no longer the legal owners of the land, they have what is called equitable ownership. The legal title currently sits with Wall at the point that the caveat has been lodged, because he's become the registered owner. Albin doesn't have the legal title. They've still got equitable. They've only got equitable title to the fee simple, or an equitable interest in the fee simple. So what we have is two equitable interests, competing equitable interests, which we then call a priority dispute between Brescobar and Albin. We'll talk about priority disputes in a while, in a few weeks' time. I was just bringing up this example merely to show you that this is how a caveat might be used in practice. In the end, in that case, the court found in favour of Albin and put their equity as higher than the Brescobar's equity. But the reason for that is because they said the Brescobars were silly, or they were disentitling conduct by giving this blank transfer document to Petrie. Right, so that's what I'm talking about. On presentation of the memorandum, there is thus a competition between the respective interests of the appellants and of the third respondent to be resolved on equitable principles. So I've put a couple of cases there on the side. We'll talk about these cases in more depth when we talk about priority disputes between competing equitable interests, that is, competing interests which are off the register. That slide merely shows the point I was making before. So we have a legal interest, where in that case it was Wall at the time that the caveat was lodged. That is, at the time that I've got my musical chairs example there. At the time that the music stops, Wall is the legal owner, and we have two competing equitable interests. So the purpose of that caveat was to stop the music, essentially, such that we could have this priority dispute before it changed hands. Right, let's move on to this second concept of a priority notice. These are relatively new part of the Land Title Act tolling system in Queensland. So relatively new, brand new. They just came in January this year, 2018. And they're basically a system that we used to have called a settlement notice. So coming up to settlement, or coming up to the closure of a transaction, we would have a party issue a settlement notice, which is not the same as a caveat. It didn't actually stop any other dealings, but like a caveat did at that strength, but would have the ability to show all these other people that a settlement was about to take place on the property. And so the property was about to change hands. Now we have this concept of a priority notice, which seems to me to be a bit broader. And essentially, a priority notice is this form you can see on the right-hand side, which seeks to reserve the priority of instruments that are to be lodged that affect a lot. So you can see a priority notice for a release of mortgage, a transfer of a mortgage on the right-hand side. So the release of mortgage is a separate form, the transfer is a separate form, and the mortgage is a separate form. So what they're saying here is, I want to lodge this priority notice, and that's going to prevent registration of any other instruments affecting the lot in a similar way to a caveat would. And it's going to preserve the place in the queue for those three documents, right? So coming up to settlement, this person has a release of mortgage. So in other words, there's an existing mortgage which sits on the title, which needs to come off, right? Because it's owed to a previous bank, or it's owed to a bank which the incoming purchaser has no relationship with. But they're going to want, when they come onto the title, they're going to want clear title, as we call it. So John Thomas Clare is going to want clear title. So he doesn't want this mortgage sitting on the title. But you can see the third document there, he's going to have his own mortgage from Sunpac Finance. So the existing mortgage comes off, which goes away with the old seller. Right. He then lodges his transfer document to ensure that he becomes the new registered owner of the fee simple. And then you've got Sunpac coming straight after that, registering their mortgage. So the purpose of this priority notice is essentially to alert those parties that these instruments are to be lodged in the following order, and it will preserve their place in the queue and therefore give certainty as to how the dealings are going to be dealt with at the point just following the settlement of the transaction. The difference between caveats and priority notices will also be a difference showing up on the title search. So if you did its title search, you'd see a caveat, for example, show up as an encumbrance on the property or another interest, which will essentially freeze the register. To stop any future dealings until that dispute is heard, for example, in the Brescovar's case. Whereas the priority notice would show up as administrative advice, which is the section below that. It doesn't allow them to then, have a dispute about some interest which might exist off the register. But what it does do is have a similar effect of freezing the register and preserving the place in the queue for this upcoming transaction of documents, whether it be a sale or a mortgage or a lease or something like that. So here's a quick example. We have Ashley entering into a contract to purchase land from Ben. You can see there on the right-hand side of the contract for houses, residential land. It's a standard contract, which you may have seen before in this course. We'll say Ben, for example, has an existing mortgage. Let's give it a number, 1, 2, 3, 4, 5. Then we have that contract is about to, that land is about to change hands from Ben to Ashley. So a transfer form 1 needs to be signed between the parties. That'll be the first dealing that we're talking about in the Land Title Act system. However, we've also got to have this release of mortgage because the existing mortgage that Ben has needs to come off the title because Ashley doesn't want to go onto the title and be subject to Ben's previous mortgage, right? So that there's another document called a release of mortgage, which is an instrument, as we now know, that needs to be lodged as well. So when that document's lodged, it will have the effect of removing the mortgage number 1, 2, 3, 4, 5 on the property, and therefore allowing clear title for the transfer to go on. So let's just say in our hypothetical example, before settlement, Ben decides to borrow further funds, right? So he signs a second mortgage with another bank called Backup Bank, right? And in order for Ashley to preserve the priority of documents to be lodged in the upcoming settlement, after the upcoming settlement, she then lodges a priority notice, that form I was talking about before, which gives notice of this settlement is about to occur, and it stops any other dealings happening with the registry. So this other mortgage to Backup Bank couldn't then be registered kind of by stealth, right? And her priority notice will essentially set out the release of mortgage and then the transfer. And if she's got her own mortgage, right, like you say, she's got her own bank that's helping her purchase the property, then that mortgage will then come after the transfer. So the order will look like this. The priority notice. The priority notice sets out first document to be lodged will be release of mortgage, which gives clear title. Second document to be lodged will be the transfer. And third document to be lodged will be a new mortgage, if there is one, which Ashley has. And this essentially will have the effect of preventing any registration of Backup Bank's mortgage. Right, so all I wanted to tell you in that podcast are the two instruments that are available. There's one called a caveat. And caveats are essentially used to protect unregistered interests in land, to freeze the register. So for example, in that case of Brescovar and Wall, where the two, where we had an equitable interest that existed off the register, they had defrauded of their interest and they quickly wanted to stop the transfer to Albin happening. So that they lodged this document called a caveat, which would freeze the register so they can have an argument about it. And the court can make a decision as to who's got the better interest. Then we also talked about priority notices. So there's a new form of this notification or instrument lodged, which would preserve a place in the queue for proposed dealings coming up. So we talked about a basic example of Ashley and Ben in the previous slide, where Ashley was about to become the new owner of the property, and she wants clear title, but she also wants to preserve that settlement actually taking place. So she, or rather her solicitors, will probably lodge this thing called a priority notice, and that priority notice will ensure the release of the existing mortgage that Ben had, the new transfer in favour of Ashley, and then potentially, if she has her own mortgage, the new mortgage will go onto the property. Right, that's it. That's all I wanted to talk to you about in that podcast.